Hello and welcome to Topic 9, Lecture 1. And in this lecture, we're going to be learning about court structure. In this lecture, we're going to take a look at three things. The first thing that we're going to look at is we're going to learn about what courts do. In other words, what is the function of the courts? The next thing we're going to take a look at are the different types of courts that we have in the U.S. court system. And then finally, we're going to look at the organization of the court system, both at the federal level and also in the state of Wisconsin. So that's what we have on the docket. Let's go ahead and get started. So the first question we're going to answer is, what do courts do? And the best way to think about what courts do is to think about them in relationship to the other branches of government within the United States system. And so, as you probably know from high school or a class that you've taken in college, there are three branches of government in the United States, and they all have separate powers. The first branch is the legislature, okay? And what the legislature does basically is they make decisions, okay? And so as it relates to the criminal justice system, as we know, it's the legislatures who engage in substantive criminal law. They make decisions about what behaviors constitute crimes. They also give an idea of what punishments someone should receive for engaging in that crime. And so legislatures make decisions. Executive branch enforces those decisions, okay? In other words, it enforces the law. And that's why it's often known as, the executive branch. It executes the law. And so in the criminal justice system, that the police are part of the executive branch because they enforce criminal law, as does the prosecutor. And then the Department of Corrections is also part of the executive branch because it enforces the criminal punishments that have been meted out against people. So what do the courts do? In other words, what is the function of the judiciary? Well, what the judiciary does is that it settles disputes. It settles the disputes that arise over the law itself, and it also settles disputes about the enforcement of the law. So let's look at this in more detail. So what kind of disputes do the courts settle? Well, there are many different kinds of disputes, and you've probably even seen these throughout the course of the semester. One dispute that the courts settle is whether or not somebody committed a crime. And so that's the whole point of a trial, that a person is accused of committing a crime, and then the prosecutor has to prove beyond a reasonable doubt that this person actually did commit the crime. And so the courts settle that dispute over the commission of who committed the crime. The courts also deal with settling disputes over civil law. And so remember, we talked earlier in the semester about the difference between criminal law and civil law. And so in civil law, it's basically you're settling the dispute over who the responsible party is, which of the parties broke the contract, which of the parties is responsible or not responsible for careless or negligent behavior. And so that is the dispute that civil courts settle. Some courts focus on the constitutionality of law and also the constitutionality of the enforcement of law. And so one dispute that is settled is the law itself constitutional, or the way that law is enforced, is it constitutional? Okay. And so, an example of figuring out whether a law is constitutional is a law that sets the death penalty for non-capital offenses, right? So the death penalty for rape or the death penalty for shoplifting, right? I mean, that's an absurd example. And that question may come to the court, right? I mean, the one on whether the death penalty can be used for non-capital rape has come to the court. And the dispute is that kind of punishment constitutional as it relates to the Eighth Amendment? Is it cruel and unusual punishment? And so the courts that settle that dispute in the case of rape as a death penalty for rape, they said no, that is not constitutional, that it is cruel and unusual punishment because it's not proportionate to the crime. Also, the question will come: are the actions of the executive branch constitutional? And so, we just got done reading about police and the rule of law, and whether a search, that action is constitutional. And so, disputes are settled around that. Now, I do want you to keep in mind when it comes to the United States Supreme Court, there's this thing called judicial review. And the Supreme Court has the ability to nullify laws that are found to be unconstitutional. Okay. So if the Supreme Court finds that laws that set the punishment for death penalty are in fact unconstitutional, then that law at the state level or at the federal level is nullified. That's one of the major powers that the Supreme Court has in the United States. All right, so let's move on now to take a look at the overview of the United States court system. And so, as we said at the beginning, we know that courts have different functions. We're going to take a look at that. And we also know that courts have different jurisdictions. In other words, that courts have different authority to make legal decisions or judgments. Okay. And the American court system is a reflection of the different functions of courts, the different jurisdiction of courts. And in a little bit, we're going to talk about how the court system and how it's organized in the United States is a reflection of federalism and federal supremacy. So let's start with the different functions of courts. So there are three types of courts that we're going to be learning about: trial courts, appellate courts, and Supreme Courts. So let's take a look at how these courts are different. So the first type of court is a trial court. And as the name suggests, the trial court is where a trial takes place. The trial court is the first court to hear a case within the criminal justice system. And trial courts exist both for civil cases, for civil law, and for criminal law. And it's the trial court that you are going to do your courtroom report on at the end of the semester. You will be visiting a criminal trial court, not a civil trial court, but a criminal trial court. Trial courts, there's a lot of actions that take place, and I'm sure you're familiar with it. It's in the trial court where, a person is tried for the crime that they are charged with. There, you'll hear evidence, testimony. There is sometimes a jury, but sometimes a judge that renders a verdict. Okay. And, depending upon whether it's a civil or a criminal trial, the verdict can be different, right? In a criminal trial, it is guilty beyond a reasonable doubt. And in a civil trial, it's responsible due to the preponderance of the evidence. Now, keep in mind, as we know, the vast majority of cases do not go to trial. That doesn't mean that the trial courts aren't doing something. The vast majority of trial courts' activities are taken up in pretrial activities, which we're going to be learning about in a week or so. And so when there is when a person is first hears, what they're being charged with, a preliminary hearing, an arraignment that we just recently saw, any sort of plea agreements, all of those take place in the trial court. That is what a trial court does. The second type of courts is the appellate courts. And as the name suggests, appellate courts hear the appeals of the trial court decisions, okay? And so appellate courts don't hear cases for the first time. Appellate courts hear cases after it's been heard by the trial court, okay? Now, keep in mind that those who, particularly in criminal law, that if you are convicted and found guilty, everybody has a right to at least one appeal, okay? You can appeal the decision of the trial court. I do want to remind you that the state in criminal law does not have the right to appeal the outcome, the verdict of guilt, okay? That would violate the Fifth Amendment, double jeopardy clause. And that basically, if the state could appeal, right? The trial found that this person was not guilty, we're appealing that decision, right? They could just retry that person until they got the outcome that they wanted, a conviction, okay? And so it's only the person who is convicted of the crime found guilty that can ask for an appeal. In civil cases, both parties can ask for an appeal, okay? In terms of, because it's not individual versus state, it's person versus person, and each of them can appeal the outcome of the decision. The main goal of the appellate court is to correct errors, okay? And so that when it comes to correcting the errors, that if you're found guilty, you might say, look, I was found guilty. However, I didn't have proper counsel, or evidence was admitted that shouldn't have been admitted because it was illegally collected, that the jury was biased, what have you. And so then the appellate court would look at that information, those claims that there were errors that took place. There's no testimony that takes place in the appellate court, okay? It's not like there's new evidence that's presented, but what appellate court justices do is that they read briefs from both the state and the criminally accused, the lawyers of the criminally accused, and the briefs will say there were errors or there were not errors, and they read those briefs and then they make a decision accordingly, okay? So there's no activities like the activities in a trial court. That the justices, and usually it's a bank of justices from 3 all the way up to 9 with the Supreme Court of the United States, they rely on court records and briefs to drive their decision making. What are the decisions that an appellate court can make? Well, there are 3 major decisions that they can take. One is that they can affirm the decision of the trial court, okay? So they basically said, we looked at the court record, we looked at the briefs, and we found that there were no errors that took place, and so we affirm the decision of that this person is guilty. Another thing that they can do is they can remand or send the case back to the trial court. A remand will take place if there was an error that was found, okay? And so they would say, look, that we looked at the court records and we found that evidence was used that should not have been used. It was illegally collected. So we're going to send this case back to the trial court for retrial if the prosecutor decides to retry, and that you retry it with not including that evidence or with giving proper counsel or whatever the error is. A reversal is basically vacating the decision of the lower court. The appellate court can say, we've looked at the court record, we've looked at all the briefs here, and we found that the decision of the lower court, the guilty verdict, was wrong, and we're reversing it, right? And we're basically saying that this person is not guilty. Usually on a reversal, there is no sending it back to the lower courts. If a decision of a lower court is reversed, it ends there. So the last court we are learning about is the Supreme Courts. And the Supreme Court is usually known as the court of last resort because it is the highest court in the court system, and it is the kind of court that makes the final ruling on a case. We have Supreme Courts at the state level. So as you know, Wisconsin has a Supreme Court, but the highest court of the land is the United States Supreme Court, which you'll be learning a lot more about in the cool video you're going to be watching about SCOTUS. Now, keep in mind that Supreme Courts usually serve as an appellate function. That's usually their jurisdiction. However, when it comes to the Supreme Court, there are times when the Supreme Court can actually hear a case for the very first time, but that does not happen very frequently. All right, the next thing that we're going to talk about is the concept of jurisdiction and the different sorts of jurisdictions that courts have. And so jurisdiction is defined as the authority to make legal decisions and judgments. And courts have different jurisdictions. Not all courts have the legal authority to hear a case. So let's take a look at the different types of a jurisdiction that courts have. All right, so some courts are what are known as courts of original jurisdiction, and basically that means that they're the only court that has the legal authority to hear the case for the first time. And so trial courts are courts of original jurisdiction. Courts of appellate jurisdiction, they can't hear cases for the first time. They can only hear cases on review, okay? And so that they only have the legal authority to hear cases on review. Now, as you're going to be reading in the textbook, that there are courts that are known as courts of limited jurisdiction. And what that means is there are courts that can only hear certain types of cases. because basically the law says, hey, this court can only hear these kinds of cases. And so some examples of limited jurisdiction courts are municipal courts. Municipal courts can only hear cases that deal with the city matters. That's what city or town matters. A family court, they only hear like divorce, custody cases. And when it comes to the criminal justice, that are the courts of limited jurisdiction, they're sometimes known as specialized courts, are courts that are dedicated to hearing drug cases only or hearing domestic dispute cases only. And so you'll read more about those courts of limited jurisdiction in your textbook. And then finally, there are courts that are known as courts of general jurisdiction. And that basically means they may hear any type of case, any type of civil case, or any type of criminal case. And so that's just an overview of what those words mean when you hear original or appellate jurisdiction. All right, so the last thing we are going to talk about is the organization of the U.S. court system. And I want you to keep two things in mind: that it is a reflection of federalism, how it's organized, and also a reflection of federal supremacy. So first, in the United States, federal law is supreme. In other words, federal law takes precedent over state law if state and federal law come into conflict with each other. This is in the Constitution. It's in Article 6, Section 2. It's known as the Supremacy Clause. And a really good example of this, a simple example, is the conflict between when it comes to drug laws. Okay, as we know, many states are, legalizing the recreational use of marijuana. However, that marijuana is still a controlled substance in federal law. And so that federal law is supreme. It takes precedent over the state law. So if for some crazy reason the Department of Justice wanted to go in and to Colorado, Illinois, where have you, and bust all the people running the drug dispensaries, they could do that if they wanted to, according to the Supremacy Clause. They choose not to because they have better things to do with their time. But at the end of the day, federal law trumps state law, and that's reflected in the way our court system is organized. Another thing to keep in mind is that the United States is what's known as a federal system. Our Constitution creates a system of federalism. And what federalism is that it's basically a power-sharing relationship between the states and the federal government. The federal government is authorized to do certain powers, and that the states are prohibited from engaging in certain activities. But whatever the states are not forbidden from engaging into and that are not authorized to the federal government, those powers fall to the states. And that's what's known as the reserved powers. It comes from the 10th Amendment in the Bill of Rights. And they're oftentimes referred to as the police powers. And so the way that our court systems are set up, and really our criminal law is set up, is that we reserve most of the power to regulate the behavior of people that lives in states. That is regulating, making decisions about what kind of behaviors are criminalized. We reserve that to the states. And you'll see that that's reflected in the way that our court system is organized. So these principles, as I stated, are reflected in the organization of the court system in the United States. So let's take a look at that organization. All right, so this brings us to the diagram that illustrates how the U.S. court system is organized. And right off the bat, you can see that federalism is one of the big organizing principles for the U.S. court system. On the one hand, you have federal courts, and so that if you are violating federal law, that you will be tried at the federal trial court levels. And so U.S. district courts, there are 94 of them in the United States. This is the federal trial court system. And if you don't like the results of the outcome at your federal trial court, you can appeal it to the U.S. Circuit Court of Appeals. Now, the vast majority of criminal law is not left to the federal government, but it is left to the states. So most criminal cases work their ways through the state system. And all states have different court systems. So there are 50 different state court systems, and each one is similar in many ways, but has its own unique characteristics, and it's defined in either the state's constitution or the state's state statute. And so states have trial courts, state appellate courts, and state Supreme Courts. In a moment, we will briefly look at how the Wisconsin state system is organized, okay? And so, if it's a state matter, it works through this way. If it's a federal matter, it works through this way, okay? However, there are times that if you're in a criminal court, if you are tried and convicted, you might want to go ahead and appeal directly to the U.S. Court of Appeals if it deals with a federal matter. And so a lot of, like rights that are afforded to the criminally accused, such as right to counsel, could be immediately appealed to the U.S. Court of Appeals. And also if it's a question of a violation of the Equal Protection Clause, could go there, okay? So there are times where that it's appealed at the federal level. And then finally, that as you work your way up, whether it's an appeal through the state system or an appeal through the federal system, you could ask the Supreme Court to hear your case if it is a matter of that deals with federal law or the Constitution. And then the decision that the Supreme Court of the United States makes is final for the most part. An amendment to the Constitution could be passed that could overturn the decision of the Supreme Court. A new court could overturn the decision of a previous court. Okay, but again, this is a really good example of federal supremacy, and then also the division of power between the states and the local governments. I'm sorry, the state and the federal government. So let's just do a quick overview of how the Wisconsin court system is organized. And so that you have courts of limited jurisdiction. They're known as municipal courts, and they have exclusive jurisdiction over ordinance violations, okay? And so that might be building violations, burn violations, any ordinance. Ordinance is a rule that is exclusive to the city or the town that you live in. And there are 237 of those courts. The state trial court, so if you're being tried for violating Wisconsin state criminal law, you're going to be tried in what's known as the circuit courts. And this is where you're going to go and do your court report, okay? It is that the circuit courts have original jurisdiction in all civil and criminal matters within the state of Wisconsin. And it is the county district attorney or the county DA that it's their office based in their county that works in the U.S. or the Wisconsin circuit courts. And there are 249 of these. And the circuit courts are organized according to counties. So Waukesha has their circuit courts, Milwaukee has their circuit courts, etc. So Wisconsin has an intermediate court of appeals. And so the state of Wisconsin is divided up into 4 appellate districts. There are 16 judges that serve in those 4 districts. They are elected. All of the judges are elected in the state of Wisconsin, and they serve a 6-year term. And just like the other court of appeals we've talked about, that they review the decision of the circuit court, correct errors, and that they rely on court records and briefs to make their decision. And then, as we all know, since we just had a Supreme Court election recently within the state of Wisconsin does have its own state Supreme Court. There are 7 justices. They're elected to 10-year terms, and they have they're the court of last resort as it applies to Wisconsin state law. Okay, and obviously they have appellate jurisdiction. All right, that's it for this lecture. In the next lecture, we're going to be learning about 2 aspects of court personnel, and it means that we're going to be learning about the prosecutors and the defense attorneys. As always, thanks for listening and paying attention. I appreciate your time and consideration, and I will talk to you again soon.